Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we have all gathered here for one of the important exams in the AOR examination on professional ethics. We have the honor to have with us today Senior Advocate Guru Krishna Kumar, sir. We welcome you, sir, and we're thankful to you for taking out time. We're showcasing this lecture live on YouTube, and if anybody has any questions, the same may be put in the chat box and the same will be taken up in the end by Sir. I now request our President to please start with the session.
Good evening, everybody, and welcome, Guru, sir. And as your name suggests, you are a guru to all and many. And this topic, I feel, professional ethics is of critical importance, not just to the people who are taking the exams, but also to lawyers as a community. And you have been a shining example of professional ethics in action in courts. And you come from the chambers of Attorney General K.K. Venugopal, who's a Bhishma Pitama of professional ethics. So it will be a wonderful treat for all of us to hear you. Over to you, Meenakshi.
I'll just start with the lecture with a brief introduction about Sir. Guru Krishna Kumar Sir is a senior advocate practicing in the Supreme Court of India. He was designated as a senior advocate by the Supreme Court of India in 2012. He graduated in law with a university rank. He has pursued a program in English and EC commercial law through British Evening Scholarship Program. Even while in college, he actively participated in debates and moot court competitions. He represented India in the Philip G. Jessup International Moot Court Competition in 1991 and finished in one of the top 8 teams of the world. He has extensive experience over 3 decades in litigation, having appeared in important cases in various fields of law like constitutional law, commercial and corporate laws, including intellectual property law, arbitration law, insolvency and bankruptcy law, election law, etc. He's appeared in many important and sensitive constitutional political matters. He's also served as an additional advocate general for the state government in the Supreme Court of India. His transnational work experience includes appearance in international commercial arbitrations, advising clients on Indian law in disputes involving conflict of laws. He has participated in seminars and conferences at the national and international level and presented papers on various legal issues on topical importance. I request you, sir, to please start with your lecture now.
Very good evening to everyone. Many thanks to Vipin for the kind words and the generous words of introduction, so as also to Rina, Nikhil, and Meenakshi and all the other office bearers. And of course, a very good evening to all the AOR aspirants who are preparing for their examination. I'm able to see that all of you are in the middle of some very, very hectic preparation for the AOR examination. It is an examination which calls for tremendous amount of focus, concentration, and preparation. And once you do all of this, it becomes a very easy examination. To start with, I'm not too sure whether it's a coincidence that the AOR Association has asked me to speak about the paper on advocacy and professional ethics for a second time this year. The only inference I'm able to draw is that last year I'd spoken on the same topic, and because I'm being asked to speak about the same subject this year also, perhaps the AOR Association feels that I did not pass the lecture last year, and therefore I'm being asked to redo the exercise this year. I mean, all jokes apart, as Vipin was pointing out right at the outset, by itself, keeping aside the preparation for the examination, and keeping aside the nitty-gritty of what really are the important topics for which somebody has to prepare for, it is very important to remember that professional ethics constitutes the core of a practitioner's day-to-day work and sustenance as a professional. It is something which constitutes the core of the value system of the profession itself. It is a reflection of the standards which are followed in the profession and a direct reflection of the values which the bar stands for. To that extent, as what Vipin said, this is a very, very important topic, quite apart from the need to prepare from an examination perspective. I think all aspirants will agree with me that there needs to be an excellent grounding in professional ethics for organic development of the profession itself. Having said that, let me clarify one other aspect right at the outset. I am not going to be going into individual case law in terms of what was decided in one particular case or what was not decided in another case, whether a particular act constituted misconduct for the purposes of the advocates or not. I would rather be focusing on some important principles and important issues, which are really the cornerstones on which the professional ethics and advocacy of the profession are based. I think that will possibly and potentially be of greater use so that all the aspirants are able to appreciate the principles and the concepts behind each one of these topics, and will therefore be consequently in a better position to address the questions which are asked to them. So therefore, having given this clarification, I think the first thing one needs to bear in mind is this: what is it that is meant by this expression professional ethics? Even last year, I did speak about it, but I think it's important to speak about it again this time also, because this is the most fundamental issue on which there needs to be clarity of understanding. Now, when we talk of professional ethics, we talk of certain standards which have to be followed by a professional. And when we talk of standards to be followed by a professional, a more fundamental question comes up right at the outset: who a professional is. This is where the starting point of any understanding, any discussion, and any debate on professional ethics and advocacy will start. In the first place, the ethics that we are talking about is something which is peculiar to professions and professionals. And something which forms the basis of this, or the premise on which this is based, is the fact that a profession is different from a trade or a business. So this is the first point which needs to be borne in mind. When we talk of professional ethics, we talk of a profession and a professional who is different from a businessman or a trader. In fact, there are 4 distinct qualities and 4 distinct features which are recognized of a person who is called a professional. First and foremost, a professional is a person who has specialized knowledge and training in a particular sphere or field of activity or study. And that knowledge or study is more mental than manual in its actual working. That's the first point to be noted. The second point to be noted is that the person has a certain duty and is expected of a level of honesty and propriety and probity which is higher than that of a person who is ordinarily engaged in business or trade. So much so, the person who pursues a profession is someone who is intertwined with larger public interest in the interest of the community itself. So this is the second most important factor to be noted. Third aspect is, when we talk of profession and professional ethics, we talk of a certain set of standards which are brought into existence by the peers of the profession itself. And the conduct and the activities of the professional are judged against those standards by a body which is elected from amongst the professionals, and they decide whether a particular conduct is something which is unbecoming, unprofessional, or is a misconduct. This is the third most important aspect. The fourth aspect is the professional, or any professional is a person who has, by definition, a higher standing in the society in comparison to any other person of any other calling. I think these 4 important features of a profession and a professional have to be borne in mind whenever somebody talks of professional ethics. In fact, these 4 principles have been taken note of in all standard textbooks which deal with professionals, professional ethics, and professional negligence. So much so there are decisions of the Honorable Supreme Court of India which have taken note of these principles. For example, when someone talks of the medical profession, and there are cases concerning medical negligence, in many of these cases, who a professional is and what constitutes professional conduct and what constitutes negligence or professional misconduct is all considered on the touchstone of these four principles. Therefore, I would commend to all aspirants to bear in mind this essential premise on which professions and professionals are organized to function. This is the first point to be noted. Now, connected to this is one other aspect. Having looked at what a profession is, it is very obvious to see, and all of you would have by now come across the very clear and easy position to understand that when we talk of professions and professionals, we are broadly looking at 3-4 areas of activity. One, profession of advocates, profession of doctors, architects, chartered accountants, and people of the like. In fact, amongst these, and even amongst these, the profession of advocates is sui generis. That is, it is one of its kind. This is the second most important aspect which needs to be borne in mind. All of us have repeatedly come across, and I'm sure all the aspirants in the course of preparing for the examination or in the course of their practice in the last few years when they have started their practice would have repeatedly come across judgments and articulation of the principle in court by the judges, by fellow advocates, by senior advocates of how the profession is a noble profession. Now, where does this come from? The principle behind this, the basis of this is that the legal profession is sui generis, which is distinct from all other professions apart from businesses and trades. One recent decision of the Supreme Court you could bear in mind, and I think you should make note of, is the decision of the Supreme Court of India last year when a question arose as to whether advocates in the discharge of their duties, in the performance, in the rendering of services to their clients would be amenable to the provisions of the Consumer Protection Act. The Supreme Court, while holding that advocates are not covered by the mechanics of the Consumer Protection Act, held that the profession being sui generis cannot be compared with other professions or business and trade. So this judgment is something which will have to be borne in mind to look at the discussion on these aspects that I pointed out to you. Please make a note of the Bar of Indian Lawyers versus D.K. Gandhi. It's a reported decision. You really need not bother yourself to note down the citation, etc. I will not burden you with all of those. Once the lecture gets over, like last year, I had asked my colleagues to circulate a note to all the aspirants where the important judgments topic-wise will be furnished, and you can have a look at the discussions and the important findings, conclusions, and ratio of all these judgments. So please bear in mind the principle which has been laid down in this judgment. Now, therefore, this broad premise having been set out, and this being the basis on which there has to be any understanding of what constitutes professional ethics, the next important point to be noted is how the profession is organized in India. All of you would have by now come across various provisions, and if I may say so with all your sincere preparation, gone into chapter and verse of the provisions of the Advocates Act. The Advocates Act is really the codification of the functioning of the profession itself in India. The Advocates Act was made to consolidate the profession, the functioning of the profession, the manner in which it will be organized, and what the obligations are, what the rights are, and all other connected aspects with regard to the profession. Important points to be noted while talking of the Advocates Act is one, the Act has provided for creation of a national body called the Bar Council of India, which has certain functions to perform. Then you have state bar councils. You have provisions which set out what the qualifications are for a lawyer. what the qualifications are for a lawyer to be entitled to practice as an advocate. There are also provisions which are made for action to be taken against lawyers for misconduct. And these provisions with regard to misconduct are really the most important point to be taken note of in preparing for the paper on professional ethics. Please make a note of certain sections of the Act which you will have to have a very clear idea of, and all the case laws which have been decided under these sections. Remember Section 7, which talks about the functions of the Bar Council. Section 49, which talks about what actions and what rules can be made by the Bar Council of India. That's the second provision you need to bear in mind. Remember Section 24 capital A, which sets out the disqualifications for a person from being enrolled as an advocate. Remember also, very importantly, Section 35. Section 35 is at the heart of the issue of and the principle of professional ethics. Section 35 provides that an advocate can be proceeded against for any conduct which is not acceptable by way of professional standards and can therefore be proceeded against for misconduct, either professional or otherwise. That is very important to be remembered. Section 35 says that disciplinary action can be taken against any advocate for misconduct which is professional or otherwise. I am not going into the nitty-gritty of how it takes place, how Bar Council will look at any complaint which is given, or it can take suo motu action, or for that matter, how the Bar Council of India can withdraw a complaint to itself, formation of disciplinary committees, how an appeal is provided against a decision taken by a Bar Council to the Bar Council of India, thereafter appeal to the Supreme Court. Those are all the provisions which deal with procedure. In the course of your preparation, I'm sure you will go through all those provisions. I'm not burdening this lecture, given the paucity of time, with the nitty-gritty of all this. But the point I want to highlight is this, and this is something you need to bear in mind, because this is where the understanding of the working of the Act and what constitutes misconduct will become easier to understand. As I told you, Section 35 talks about a lawyer being liable to be proceeded against for misconduct, both professionally and otherwise. This means that if there is any misconduct in connection with his professional work, conduct in connection with her professional functioning, that can be proceeded against if it constitutes misconduct. Equally, other misconduct which is not directly relatable to professional work can also be proceeded against. This is very important to recall, because this is something where, given the nature of the profession, an advocate is supposed to function at certain level of probity, given the fact that the advocate is part of the larger justice delivery system. In fact, the recent decision of the Supreme Court that I spoke about a little while ago, that mentions about how the lawyers are an important adjunct of the justice delivery system. Therefore, the law provides that misconduct which is not directly relatable to professional activity is also amenable to disciplinary action. It is in the light of these provisions that there is legion of case law on what constitutes professional misconduct and what constitutes misconduct other than professional misconduct. Therefore, all these cases you will have to understand in the light of the fact that both professional and other than professional misconduct is amenable to disciplinary jurisdiction. Please also bear in mind one other important aspect. Misconduct by itself is not defined under the Act or under any of the rules or regulations. Misconduct has been judicially interpreted by the Supreme Court of India in certain cases. Those cases, again, I will give the list of them. You can read them because we are getting into certain nitty-gritty, which perhaps we can avoid. And I would rather that the aspirants read them themselves to have a clear understanding and really appreciate and digest the nuances and the ingredients of what constitutes misconduct and what are the standards on which misconduct will be judged. So this is one important point to be borne in mind. Point one being what a profession is and what the nature of the legal profession is connected to that. Second point is the codification of the profession through the Advocacy Act and the important provisions. Third connected aspect to this is the rules which have been made by the Bar Council of India with regard to professional standards. There, please remember certain headlines and highlights. One, lawyers have duties of different types. One, duty towards the court, which is extremely important. Two, duty towards the client. Three, duty towards the opponent. Now, these are all distinct duties. What is important to be borne in mind by anyone preparing for the examination is that the duties which are spoken of may often appear to be and seem to be conflicting with each other. But given the sui generis character of the profession, it becomes necessary to understand the rationale behind each set of the duties. Therefore, it is important for an aspirant to remember the manner in which there are duties set out in respect of a professional towards the court, towards clients, and towards opponents, and a whole set of other duties. Case laws which have decided on these points are also available, but you must remember that there is at the end of the discussion on this subject that the importance of these duties have to be understood in the context of the larger public interest which is involved, since the profession of lawyers is part of the justice delivery system. In fact, each one of these duties has been brought in to ensure that the lawyers function in a manner which will best subserve the larger purpose of administration of justice. This is therefore the third aspect which I wanted to highlight. Now, these are topics on which questions are asked every year because they form really the bedrock of the manner in which the profession is organized and the manner in which lawyers function on a day-to-day basis. There are also other topics which need to be looked at, whose principles, whose ideas, and whose concepts have to be fully digested. And some of them I'm going to flag to you because given the time constraints, it may not be possible to discuss all of them in great detail, but I will flag some of the most important ones. One, advertising by lawyers. Is it permissible or not permissible? Now, please look at straight away Rule 36 in Chapter 6. Rule 36, in fact, was in absolute terms saying that no kind of advertising, no solicitation of any kind can be made at all. Now, this rule underwent a change in 2008, by which it was made less rigorous. Now, the rule as it stands today, even while prohibiting advertising, solicitation of work of any form and in any kind, and various other restrictions connected to it, enables lawyers or permits lawyers to give out information to the public which have some bearing on what are the details of the lawyer. As for example, the degree that has been obtained from which university, the date of enrollment, the areas of practice of a lawyer, and such other details. In fact, there is a table set out in the form of a particular format which has been set out where all these details can be given. The reason why I'm highlighting this is because the issue of advertising by lawyers is something which has been the subject matter of repeated questions in examination over the years. And it is not without reason that this topic has been questioned upon in that sense, because in the modern day scenario, a very pertinent and relevant question will arise. Is it right or wrong for professionals to advertise or not advertise. One of the important points raised in favor of the position that advertising, though limited, must be permitted is this: clients have a right to know. Clients have to know the person to whom they are going is a person who has a specialization in a certain field. Clients have a right to know whether a person to whom they are approached for legal assistance has specialized knowledge in a certain branch of law in which they want legal help. So, one of the strongest points in favor of providing for advertising by lawyers is the right of a client to know. But that has to be counterbalanced and seen against the larger problem of misleading claims by a professional. It also has to be seen from the larger lens of the fact that the profession itself is a noble profession, which is unlike any other profession or any business or trade. And a lawyer is not supposed to do any kind of advertising or solicitation. Therefore, please remember that Rule 36 in its present form has certain limited window of information being made available to the public on a lawyer's background, but can never be a background or basis or platform for advertising. In fact, there are a couple of decided cases on advertising, which again will form part of the note that I spoke about. But something more recent on this subject is something which all aspirants have to bear in mind. Very recently, the Bar Council of India, sometime in March of 2025, has come out with a press note on unfair, impermissible, and unjustified advertising and solicitation of work by lawyers. The Bar Council of India has, in very unequivocal terms, said that there cannot be any advertising or solicitation by lawyers strictly consistent with Rule 36, and how any kind of publication of information by a lawyer has to conform to the strict rigors of Rule 36. Now, the reason why I'm highlighting this press note is this: all of us are today in the digital era. We are now in this era where the kind of technological advancements which have occurred have made possible things which were unthinkable even 10 years back. We are living in the age where artificial intelligence is taking over all fields of human existence. Today, we are talking of how AI can be brought in meaningfully for justice dispensation. Now, with all these developments taking place, there is another aspect which needs again to be borne in mind: the growth of social media. Today, the growth of social media is so very significant and impactful that one can even go to the extent of saying that there cannot be a person who can have an existence meaningfully today without being part of social media. Knowingly or unknowingly, all of us become part of social media. The prevalence of social media is so significant, so widespread, and so rampant that it simply cannot be ignored. Naturally, a question will arise: what about presence of lawyers in social media? What about their projecting their services on social media? It is in the context of this that the press note that I spoke about, which was issued by the Bar Council of India, becomes relevant. The press note which has been issued talks about how there cannot be any attempt to use social media to engaging in unfair advertising or solicitation of work. In fact, Bar Council of India has taken note of the new type of persons, an expression used called legal influencers. In fact, certain set of do's and don'ts have been set out in the press note itself. All of you would therefore do well to make a note of this, digest the contents of that note, and have a clear idea of what the latest position is of the regulator on the subject. Please make a note of this. It is called the press release of the Bar Council of India dated 17/3/25. Now, the caption is: Bar Council of India takes strict view of unethical legal advertising, misleading social media promotions, and professional misconduct by advocates, legal influencers. All of you, therefore, do well to have a look at this and understand the implication of this on the larger subject of advertising by lawyers. Now, therefore, this is another topic which will have to be borne in mind. One more topic, which is often, and in fact, invariably always been the subject matter of questions in examination papers in the last few years. And that is with regard to the strikes by lawyers. Now, lawyers have organized themselves into a profession. They have their grievances. They, being a part of the justice delivery system, they will have a very strong voice and view on burning issues concerning the profession itself, and importantly, concerning the independence of the judiciary itself. After all, lawyers are an important part, and as the Supreme Court said, adjunct of the justice delivery system. So if there is any development which has a bearing, an adverse effect on the independence of judiciary, do lawyers not have a right to protest? Do lawyers not have a right to resort to strikes if their genuine grievances which are voiced are not addressed? These are all the questions which have been raised, because like any other member of the society, and more so being a responsible member of the society, are not lawyers entitled to voice their concerns, voice their grievances, voice their views on issues of moment, issues of national importance, issues of importance concerning the judiciary itself? Now, these aspects have been addressed by the Supreme Court of India in Harish Supal's case. It's a constitution bench judgment of 2001. The aspirants would do well to study what are the circumstances under which there can be protests which can be undertaken, what kind of protest can be undertaken, and to what extent it can be done, have all been set out in that. But please bear in mind, strikes by way of abstention from work is not permissible so far as lawyers are concerned, subject to only an exception that they can perhaps engage in a strike for a day, that too for certain specified reasons and conditions. Therefore, it is important to bear in mind the judgment in Harish Uppal's case and a few other cases following that, and referring to the principles laid down therein, where the issue of strikes by lawyers has been looked at. All aspirants, once they have a clear idea of the principle behind the decision of the court and the rationale behind the decision of the court, will be able to address any questions which are asked on the issue of strikes by lawyers. One other aspect, lawyers, I pointed out right at the outset, are subject to the disciplinary proceedings and disciplinary action by the Bar Council of India and state bar councils. What about the power of the court to take action against them? So this is another topic which has been a mainstay, if I may say so, in question papers over the years in an AOR examination. Does the court have a power of taking disciplinary action against a lawyer? Where does the court stand, or where does the regulator stand vis-a-vis the powers of the court? Here, the aspirants will do well to remember the power of the Bar Council to take disciplinary action for misconduct as against the power of the court to take action for contempt. This is something which forms the core of the understanding of the topic on power of court to take action against lawyers. That has to be understood from the prism of how power to take disciplinary action vests with the statutory regulator under the Advocacy Act, and the power of the court is really for taking action for contempt of the court itself and not by way of disciplinary action. If you understand this principle, all the case law, which I will be giving to you in that note, will give clarity to you on how the approach has been taken by the courts. In fact, you must also bear in mind one provision being Section 34 of the Advocacy Act. That provision gives power to the court to frame rules on the conditions on which an advocate can be permitted to appear before the court. One interesting decision I will just mention to you, you can read it at leisure, where the Madras High Court framed rules for lawyers invoking the power under Section 34, where essentially the rule purported to take action for misconduct. Now that was challenged. Ultimately, Supreme Court of India in Muthukrishna's case held that such a rule cannot be made by the court to take action for misconduct against lawyers, and the discussion in that judgment will be very, very useful for you. Please, therefore, bear in mind Muthukrishna's case. In fact, paragraph 57 of that judgment will be very useful for you to remember, to understand the principle behind this. Now, an important case, which again you have to bear in mind, is the Supreme Court Bar Association case of 1998. There, the Supreme Court, a constitution bench of the Supreme Court, very clearly held that disciplinary power is something which rests exclusively in the bar councils established under the Bar Council Act and not with the court. The facts of the case are very interesting. When you read the facts, you will know a functionary of the high functionary of the bar was sought to be proceeded against for misconduct, for what happened in court and certain other connected aspects. A decision was taken to debar him from practice, but ultimately a 5-judge bench held that such an order cannot be passed by the court. So this is another topic which you need to bear in mind. Another important area where questions are asked is the principle of confidentiality in respect of communications between lawyers and their clients. This is again an important area for all aspirants to have clarity on and have a clear take on the subject. You must have by now read section 126 of the Evidence Act. That sets out how a lawyer specifically has a duty not to disclose communication and confidential communication which he has had with his clients. Please remember 3 important concepts here. The section itself is a protection which is available and made available to the client and not really to the lawyer. This has been made available. Some old English cases will give clarity on the subject, will show how this has been brought in to ensure that a client is able to get the best of legal assistance when he wants support to defend himself in a judicial proceeding. So the first point to be borne in mind is it is something which is a privilege which is attached to a client and not really to the lawyer itself. Second principle to be borne in mind, this is something which cannot be used for furthering an illegal purpose. Second point to be borne in mind. Third point to be borne in mind is it is something which can be waived by the client itself. These 3 principles have to be borne in mind. Please remember, along with section 126, 127, 128, and 129, which are all connected to 126, and all of you would do well to read the illustrations which are found in section 126. I'll read 1 or 2 of them because it is so very interesting and illuminative on this subject. Just take, for example, first illustration under 126. A client says to B, an attorney, I have committed forgery and I wish you to defend me. As the defense of a man known to be guilty is not a criminal purpose, this communication is protected from disclosure. So very clear, because this is something which has been done by the client already and he wants to be defended in court. B, second illustration. A client says to B, an attorney, I wish to obtain possession of property by the use of a forged deed on which I request you to sue. This communication being made in furtherance of a criminal purpose is not protected from disclosure. These 2 examples, which represent 2 extremes, will give you an idea of how the section operates. There are some interesting cases under this provision also. And again, the aspirants would do well to have a clear idea on this topic, because questions which are asked on this constitute an important part of the examination setup and structure itself. So these are some of the important topics one has to bear in mind. The nature of the profession itself, how the entire profession is structured on a codification of the Advocacy Act, about misconduct and how misconduct, both professional and otherwise, are covered by the Act, how there is a bar on lawyers resorting to strikes, the principle of advertising by lawyers. We also have the principle that the communications as between lawyer and client is something which is privileged. These are topics on which we have always questions being asked. There are also other topics which you would do well to have a clear idea of. For example, a sub judice matter. How much of it can be discussed by a person in court? And whatever he has argued in court, the same person who is appearing in court goes in front of the media, whether it be television, social media, and debates those on social media or on other media, where someone who is appearing in a case goes forward to the public and discusses the merits or demerits of the same, which has been espoused by her in court. This is something where lawyers have to be extraordinarily careful. As a matter of principle, it would be inappropriate for a lawyer who has appeared in a case to go and discuss the nuances and the merits and demerits of the same case on other media. In fact, this was commented upon, some submissions were made on it in a couple of recent cases. Now, it is therefore important that this topic is also something which lawyers bear in mind. Now, all this having been said, the topic for the examination is advocacy and professional ethics. Now, what about this idea of advocacy? And what are there questions being asked in respect of this? Now, one standard principle all of you should bear in mind is the principle which was espoused by a judge, where he spoke about 7 lamps of advocacy. Now, this is something which all aspirants must bear in mind. I'm not going to reel out all the 7 lamps of advocacy because they constitute the core of day-to-day functioning of lawyers. But you must have a clear idea on what the 7 lamps are. The reason why I'm highlighting this to you, because already you would have come across material on what these 7 lamps are. The reason why I'm highlighting this is, apart from the fact that a question is asked in every examination on this, there is one other reason. There is a decision of the Karnataka High Court rendered a few years ago, where Justice B.V. Nagaratna, as a ladyship then was, when she was the judge of the Karnataka High Court, while dealing with the writ petition, spoke about an 8th lamp of advocacy. There she said the 8th lamp of advocacy is commitment to the cause of justice. There, the context of the proceedings was the need for rules to be framed and some kind of guidelines to be made regarding strikes by lawyers and all some other connected aspects. Now, in the course of the discussion on the subject, she mentioned about the 8th lamp of advocacy. In fact, I remember way back in the 1940s, a judge of the Madras High Court also spoke about an 8th lamp of advocacy. He spoke about how tact is the 8th lamp of advocacy, apart from the 7 which were set out and have been understood to be the traditionally understood lamps of advocacy. Please, therefore, have a clear idea of the 7 lamps of advocacy and also the 8th lamp of advocacy as given by 2 other sources, or perhaps the 8th and 9th, if I may say so. Now, these are all some of the important topics which I think all aspirants would do well to prepare well for. Also, please have clarity on few other topics. I'm only going to outline the topics given the constraints of time. One is appointment of amicus curiae and what the duties are of an amicus curiae. Half the time, many occasions we find that respondents and accused go unrepresented. They are not able to defend themselves for various reasons, because of poverty, because of lack of awareness, and various other constraints. Now, courts have therefore stepped in to ensure that nobody goes unrepresented. They appoint a person to represent such people who are not able to engage lawyers of their own. Now, a person who is appointed like that is called the friend of the court. Amicus curiae, as all of you would have read by now, means friend of the court. Now, there are clear directions given by the Supreme Court of India. There are at least 2 judgments which set out under what circumstances amicus curiae have to be appointed and what are the qualifications for a person to be appointed as an amicus. In criminal cases, courts have held that depending on the nature of offense and the nature of punishment involved, there needs to be a minimum standing for the person who is appointed as an amicus curiae and various other such conditions. And there are also duties which are owed by the amicus to the court, and to ensure that he or she defends the cause of the person whom he is asked to represent, while at the same time being an officer of the court. This is another area where everybody must have clear understanding what the topics are. I would think these are some of the most important aspects which you need to bear in mind while preparing for the examination. This is an examination which I said right at the beginning, which is not very easy if you're not prepared, but is something which you can write very well and do very well in if you're prepared very well. So I would wish all of you all the best in the examination, and hopefully with the case law that you will be reading and the principles which have been set out in various cases, you will have better clarity of the concepts which I've tried to highlight during the course of the last half an hour to 45 minutes. And all of you, with your preparation, with your industry, will be able to come out with flying colors, and all the best to all of you. Thank you.
Thank you so much, sir, for such an enlightening lecture. I'll just start taking questions which have been asked in the chat box. The one of the relevant questions that have been asked is by Prakash Jadhav. He's asked that, are the advocates the mouthpiece of the client? Please explain.
Now, as I said, you remember I spoke about the duties which are owed by a lawyer, the duty to the court, the duty to the client, and the duty to the opponent. The lawyer is a mouthpiece of the client, yes, to ensure that he furthers the cause of the client because it is the client who has engaged him. But at the same time, he has to remember that he is an officer of the court. He, under no circumstances, would be entitled to act in such a manner that the larger cause of justice is sacrificed. While he has the duty to defend his client vigorously, he also cannot ignore the duty he has to the court, and importantly, that he is part of the larger system of justice delivery, and therefore he has to draw a fine balance between the two duties to ensure that he performs his duty on both counts correctly.
Very true, sir. I'll just conclude this lecture with a word of thanks. I, on behalf of the Supreme Court Advocate on Record Association, sir, I extend our heartfelt gratitude to you, sir, for delivering an insightful lecture on professional ethics as a part of the SCAORA AOR lecture series. Your expertise in highlighting the important topics of AI, social media influencers, digital advertising, and the eighth lamp of advocacy, and key principles such as integrity, accountability, confidentiality, fairness, and respect, explaining professional misconduct, strikes, has been invaluable. Sir, your in-depth analysis of professional ethics will undoubtedly benefit the AOR aspirants, providing them a first-hand understanding of the importance of upholding the ethical standards in their profession. We appreciate your gracious presence, sir, and we look forward to have you again on board for the future SCAORA AOR lecture series. Thank you everyone who's attended this lecture in large numbers. I, on behalf of SCAORA, wish everybody the very best of luck for the upcoming AOR exam. Thank you so much, sir.
Thank you. And I wish the aspirants the best of luck in their examination, and a word of appreciation for the AOR Association for doing this year after year, which is providing a very, very good platform for the aspirants to be able to prepare much better for the examination. And good luck to everyone.